Yeah, welcome back from the break. And we will now look into the last chapter in the previous guest lecture of Christoph Zindel, which was unfortunately we couldn't record because of some of the content in the slides. He mentioned regulation already. So I'll be talking a bit about regulation today, especially linked to the AI Act. We'll be talking about whether we can actually patent AI. We will look into copyrights, as well as some military applications, as well as AI at the workplace. So the AI Act is a law that was proposed by the European Commission in early 2021, concretely in April 2021, because the European Commission believed that AI was unregulated. They claimed there were lots of legal risks around AI and they would need to be addressed. Yet they couldn't really name what was unregulated, and they proposed the AI Act. The first draft of this regulation was something like 120 or 140 pages, and it's a so-called horizontal regulation. Horizontal means AI for everything is regulated. While in contrast, there's vertical regulation, say there's vertical regulation for cars, for airplanes, for power plants, for financial products. And the belief of the Commission was that all of that AI was in general unregulated. I had very big concerns about that from the very beginning, because if you put AI in a car, if you put AI in an airplane, if you put AI in a financial product, obviously your AI needs to follow that vertical regulation that exists already, which often addresses systems and processes. So your AI is part of that system or part of that process, and obviously it needs to follow that existing vertical regulation. So it's unclear where there was actually a lack of regulation. And if there was one, it should have been closed as simple as possible, maybe by updating vertical regulation, whatever. Now, as usual for new laws that are proposed, you get quite different feedback on it. If you talk to people like me, we said it's way too much regulation, a lot of undefined terms, too many rules, no one knows how to become compliant. However, if you talk to people from the other end of the spectrum, like NGOs, workers' unions, and so forth, they claimed that all of that was not enough. We would need even more regulation. Now, we talked yesterday about how one would define AI from a management perspective to convince managers that they should invest in AI. Now, how do we define AI in an AI Act? Because if we regulate AI, we need to define it. So we need a so-called legal definition. And the legal definition in the first draft of the AI Act was something like an AI could be some expert system, some machine learning system. They differentiate also into deep learning systems, as well as every statistical method and every optimization method. Quite broad, right? Yeah. So some values is AI. That's what I said from the beginning, that would be covered too, you know. And because the mean, it's a statistical method. So to me, it was way too broad in that sense, but in a different sense, it was too narrow because it was too broad. They always wrote software is doing that. And then I said, yeah, what if hardware is doing that? And, you know, parliaments do hearings, and there was this proposal in April 2021. And in parliaments, there are different committees that look into this. And just the following month, there was a hearing in the German parliament, and it was a joint meeting of the European Affairs Committee of the German Bundestag, as well as the European Affairs Committee of the French National Assembly. And they invited 4 expert witnesses. I was one of them. And I said from the beginning that that definition doesn't really work. It's too broad, but also too narrow if it only covers software and not hardware. And I said, you can build simply a piece of hardware without any software, after the hearing, I was contacted by the people who wrote the AI Act some staffers in the European Commission. And they asked, oh, how can you do computer without software? Can you explain this? And I said, yeah, but that's what you learn in the first semester at university, just some logic gates, software just adds flexibility. They didn't know this. So I felt that people who wrote the AI Act, they really didn't have any understanding about computer science. And that sort of scares me. So I found a few years ago, this one here, if some headlines, we must regulate AI, which could maybe just mean we must regulate nonlinear regression. AI is getting better at mind reading. We could also say function approximation is getting better at mind reading, because supervised learning is just some sort of function approximation in a high dimension. And then what exactly are the dangers posed by AI? One could rephrase this into what exactly are the dangers posed by the rectified linear unit. It's obviously a bit exaggerated, but I think there's some truth to that. I found it on the internet and just wanted to share it here. So parliaments do hearings. Meanwhile, I was 3 times in the German parliament in hearings, once in the French parliament, once in the European parliament, and once in the parliament of Luxembourg. And in these hearings, they invite different so-called expert witnesses. But something I also notice, most of the people they invite to these hearings are not necessarily experts. Because do you have a clue, like in the German parliament, who chooses who gets invited? Who makes that choice in a committee? Yeah?
The experts are invited to explain it to them. How can these people define who an expert is if they meet the experts who's talking to them?
Yeah. So it's actually the parties or their fractions that choose. So in each committee, each fraction has representatives, and then one person gets invited by CDU and CSU, one person by SPD, one by Linke, whatever. And a lot of these parties, they tend to invite people that keep telling what the party wants to hear. So that's something that sort of shocked me. So I was never asked to say something specific, and I would never follow anything like this. But obviously, I was invited by, you can guess which fraction, because there was obviously a big intersection in terms of the beliefs. And yeah, but I would never really follow orders. Now, I guess you're guessing who invited me, but you can read this. It's written in the document. So it was CDU and CSU, by the way. But yeah, not a different party, But but I would never just accept some orders what to say, but I probably got invited because of my expertise, but because I also have something in mind that is maybe not too different to what they do. But yeah, and these people they invite, they're not necessarily people doing AI. There's maybe a representative from a workers' union or from some NGO. So these hearings, they are helpful, but they could work better if there were more experts. And then we sit together, there are, introductory speeches, questions, answers, but there are never really any follow-ups of these hearings. So, and then the members of parliament, they have more meetings during the day. But I warned very early about this AI Act in this form. And in such hearings, one also sometimes writes written evidence. So it's something you submit before. It's either whatever you want to write about, or there may be some written questions that you can answer. And this written evidence is quite helpful, because this is the kind of stuff then circulates into ministries and so forth for those who did not attend the hearing. I wrote also a book chapter, what seemed to be, so that this written evidence was in German, but I also wrote a book chapter about this, what seemed to me the key issues of the AI Act. You find all of these documents in Nextcloud. And then after 3 years, the AI Act was ratified. So it was for 3 years national parliaments look to national governments, the European Parliament, then you have the council presidencies that change every 6 months. And even in the European Parliament, there were more than 1,000 amendments to the first draft of the AI Act. Things like ChatGPT, they were not at all in the first proposal in April 21, but then when these models became more popular, they started adding more and more requirements into the AI Act. Now, what is finally the definition of an AI? And I told you that very initial definition, something I was very skeptical about. But now let's look at what is finally in the last version of the AI Act. It says an AI system means a machine-based system that is designed to operate within varying levels of autonomy and that may exhibit adaptiveness after deployment, and that for explicit or implicit objectives infers from the input it receives how to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. So this is definitely the definition we here would have come up in a computer science department that has a strong focus on AI. What do you think about that definition? Is it very clear, or what kind of challenges do you see? Yes. Yes. I think it's super broad. It may cover nearly every machine ever built. There were even some arguments it may cover an analog scale for determining your weight, because some critical stuff is may and can, and some input, some output, varying levels of autonomy. Does that also mean maybe no autonomy at all? You raised your hand, I think. Yes. So we looked into it, and obviously those 6 lines, they're not very clear what they mean. And now eventually courts will have to look into this kind of stuff, but that takes a long time. So in law, there's also a different type of literature, so-called comment literature for laws. And in comment literature, academics or practitioners write what that law may actually mean. So one of my friends, he edited a very big comment on the AI Act, which is, I think, more than 1,000 pages of literature. And we wrote I contributed to this definition of an AI system, but these 6 lines here turned maybe into 30 pages of comment literature, because in comment literature, you would also look at how this definition has evolved, what's the scientific view on it, how would AI be defined in AI books, what other comments came up during those 3 years of discussions in Brussels. And in the future, we would also write about court rulings in an updated version that have actually ruled about this. So far, it's totally unclear. And there are even some lawyers trying to find loopholes in this definition. And they are representing their clients that build AI. And they are trying to make the case that their client's AI actually does not fall into this definition. So the lawyers are obviously very happy because this generates more business and so forth. Yeah, so I'm very skeptical about all of this because it also adds uncertainty. It makes innovation more expensive. It certainly does not help us in international competitiveness. And last year, we had another hearing in the German parliament where it was about which agency would finally enforce the AI Act. So I'll provide you with a few more details about the AI Act, what it does. So within the AI Act, there is a so-called risk-based scheme. So you have low risk, high risk, and forbidden. So forbidden stuff is forbidden. And what they write about is, for example, manipulation of humans using AI, predictive policing, I think was also, and there are some other things. You can check the list. Yeah.
You find which are used for marketing purposes
Exactly. Exactly. So the definition is longer than what I just said. You can look it up on your own, but it's still very vague and you can interpret a lot. And some stuff is banned using AI, but honestly, maybe some of that stuff should be banned in general, independently of AI, because AI is just a tool. And other things may be banned already based on other laws like penalty codes, whatever. So then there's a low risk at the very bottom. Low risk would be spam filters, for example, or some stuff. And we hope the video is coming back very soon. And projector is still working, but somehow the cable got disconnected. So I hope the projector will soon be up and running again. Now it's probably working again, hopefully. Yes. So there's low risk, like for example, spam filters or other things. And then there's the high risk domain, which is allowed, but comes with very big constraints. And these constraints are, for example, you need to pay particular attention to your data quality. There may be certain transparency obligations, and it's not just documentation work. So for the low risk, it's largely documentation work. But for the high risk, it's a lot of work. And in the first draft of the AI Act, now for the high risk, the initial version of the AI Act had some very strange requirements, for example, about data quality. The first draft of the AI Act demanded that for high risk, you would need to have actually a perfect data set, unbiased, fully representative, fully free of error, fully complete, which doesn't really work. And to have a fully complete data set, that would be, again, most likely a violation of the GDPR, the data protection, which forces us to use as minimum data as possible when it comes to personal data. So these requirements are not that strict anymore in the latest version or the final version, yet there's a lot of uncertainty in the AI Act, what hundreds of pages actually mean. One solution is comment literature, but that's rather for professors and judges. For you in industry, you won't be able to comply with hundreds of pages. No one knows what that kind of stuff means. And it will take time until there are rulings. But what currently is happening, certain industry associations like IEEE and others for other fields like chemistry, finance, they are working on checklists together with lawyers and their AI and domain experts. And then if you apply AI in chemistry or AI in some other industry, you would maybe have a 2-page checklist that you can go through and you have 95% certainty, something like that. That's certainly more helpful than studying hundreds of pages that no one understands. And these checklists are currently in the making. Some have been completed. There are some drafts. This could be also an opportunity for you to engage. Now, in other parts of the world, or what the EU always claimed is that we would be the perfect example for the rest of the world and that everyone would just do what we are doing. Yes? Yeah, or they want to increase prosperity, scale healthcare, scale education. By the way, the AI Act even addresses education. Education is high risk, like customization of content or admission to programs or education, because they say education is a fundamental right. So if you constrain it in any way, it's a high risk. But you know, if you have a learning portal that learns, that prepares content based on your learning, on your previous knowledge, on your performance, I think overall that's very, very positive. But with high risk, we make that stuff more expensive. or maybe the innovation does not happen and it happens elsewhere. And high risk really means to me things where there's a threat to health and safety, and not just some imaginary risks that someone doesn't get admitted to some program he or she feels entitled to. In California, there was an attempt to duplicate the AI Act with the so-called AI Safety Bill, which passed the House and the Senate there, but the governor actually vetoed it just a year ago because he got a lot of pressure from the AI industry, from Silicon Valley, because they said they would be essentially moving to Texas if that AI safety bill became a reality. Because they said in the EU, it just doesn't work, makes innovation too expensive, or prevents innovation. So finally, the governor there vetoed it, which was probably a smart choice. Just a quick excursus on regulation in the EU. In the EU, there are different types of legislation. What we had so far is a regulation, the AI Act. And the AI Act is once ratified by the member states and parliament and so forth, which happened last year, then it is a binding legislative act, so it must be applied in its entirety across the EU as is. But the member states could make it even worse if they wish and add even more rules. But they have to enforce at least those rules. And we in Germany, we often tend with such laws to add even more rules on top, like with data protection, which doesn't really help. There, and Christoph, who was here before, the former board member of Siemens Healthineers, he also talked about different legislation. He mentioned the medical devices regulation, and before there was a medical devices directive. A directive is another type of legislation which sets out a goal, and then the member states must achieve that goal, but they have some freedom in how they reach that goal. They need to follow certain constraints, but these national laws, they differ. So GDPR is one thing, it's a regulation, but there are other directives that we will see later. And so the regulations apply as is in the member states, and the directives, there's some freedom in how they will finally be implemented. And there are other types of legislation in EU, like decisions, recommendations, and opinions. They are explained in detail on the website of the EU. And there's plenty of other digital regulation, like the GDPR, which is the General Data Protection Regulation, we talked already about, and the Digital Markets Act, the Digital Services Act. Have you heard about these two, Digital Markets Act and Digital Services Act? Again? Okay, but you don't know what it does, or? Yeah, so the Digital Services Act is currently the law that is being used to censor free speech on social media and so forth, because some agency or some NGO in Germany claims that what you post is incorrect or wrong or illegal, and then Facebook or LinkedIn, they have to take it down. Something I find very, very concerning if we have government hiring some NGOs that finally determine what's right and what's wrong. And it's not about crimes. I mean, illegal content anyway has to be deleted. If you call for the execution of someone or you spread illegal content, like forbidden types of pornography, that anyway had to be deleted with existing laws. So the Digital Services Act is, I think, really being misused to censor free speech. And there are a lot of examples now, like professors posting something skeptical about the government on LinkedIn, and then they disappear on LinkedIn for 2 weeks. This is now happening all the time. And the Digital Markets Act is something else. That one addresses ecosystems and wants to prevent that one gets too big. So Digital Markets Act addresses stuff, for example, like at the Apple Store, because the EU claims that this is too powerful, and that's why they reduced fees, or they force Apple to create alternatives to this Apple Store. I guess you heard this kind of discussions, right? And not just applies to Apple, but also some others. But the consequence is that a lot of services finally are not being offered in the EU anymore. Like you recently heard maybe about this new feature with the Apple AirPods, which is like Star Trek, that you get a live translation of someone speaking. If you have the latest Apple AirPods and the latest software, that feature is not being offered in the EU, in particular because of the Digital Markets Act and as well as some data protection concerns. So it's not just that this over-regulation prevents us from building certain products, but it also prevents you as a user from using that stuff eventually. Yes.
Isn't it the same?
Yeah, exactly, it's the same.
It's still not fully integrated into the German or the German configured.
Yeah, absolutely.
It was praised as the great thing and fully integration, and it never happened really.
Yeah, and for other services, if you want to use them properly, you need to use a VPN and connect to London, and then you can use some stuff that you can't use here.
It's the English, then it works suddenly. So.
Exactly. So that's really a problem. So it also finally hurts you as an end user. There's one other important legislation that, with regards to AI and software, that I want to talk about, the Product Liability Directive. I think overall it's very important that we have safe products in Europe, like safe cars, safe airplanes, safe toys, safe TVs. And finally, what happens if something goes wrong? Then liability needs to be regulated. And for that, we have the Product Liability Directive for decades in the EU, which is very, very helpful, first of all, that we have safe toys, for example, for kids. But it was always unclear whether software was actually a product as defined by the Product Liability Directive. And this had created uncertainty in the last few decades in the EU. And when the AI Act was proposed, I always said, we don't really need this AI Act, rather we need to think about liability, and we should revise the Product Liability Directive. This is something that has now happened in parallel to the AI Act, and it's also been, it's through the process. So software is now a product. I think that's overall quite helpful because it reduces uncertainty in terms of the liability. But the EU then claimed they had done the AI Act, they had done a new Product Liability Directive, but that the combination of both was still not enough. And then they proposed the AI Liability Directive, because they said a Product Liability Directive addresses software and AI, but somehow not enough. So we need another regulation. And they were so sure, even until the beginning of the year, that we would really need this AI Liability Directive. And then in the beginning of the year, end of January, early February, there was this Paris AI Summit, in which J.D. Vance, the US Vice President, gave a very clear speech against the DSA, against overregulation, and also the AI Liability Directive. And then the next day, the European Commission canceled the AI Liability Directive, which is probably a good thing. And it seemed it disappeared, so it was proposed. Recently, someone mentioned, they actually still want it, but the topic seems to have largely disappeared. We'll see in next year's class if there's an update on that. But there's something else, something we can investigate together. So if you use Google Maps and you search something like Blumenstraße, Deggendorf, then you can see this in my slide, then the map will show you something, but this map is not clickable anymore on a computer in the EU. Have you noticed this? This started like 1 year ago or 1.5 years ago, that certain Google results are visualized, but you cannot click them anymore. Or before, if you type in Berlin, Google may also suggest you some flights, for example, that you could book or other stuff through Google Flights. So certain features have disappeared or they're not clickable anymore. When this started to happen in the beginning of last year, I felt this had to do, maybe I had some cookie issue in my browser or something, but even the incognito mode didn't solve it. After a while, I found out all of this has to do with the Digital Markets Act, because the EU feels that Google is too powerful, and if they interlink between their services, this would stifle competition. But I think eventually you as an end user get stifled because you have to do extra clicks, copy paste, whatever. Because if you then want to see the map of Blumenstraße, Deckendorf, you need to click, or you need to type maps.google.com and then type your query again, which by the way will probably also trigger more CO2. So I'm not sure if that's so helpful. Yes?
This, I mean, sure, you can argue it's for the user, so they have more of a choice which navigation system they want to use. But I also, as a user, I can't decide whether I want to use European right or not. In law, so I kind of critical that they want to protect us from all the influence.
Yeah.
Maybe just top down and decide what's best for us.
Yeah, I wish I could opt out of such laws, and just say I accept that there could be less competition, but I just get a very, very good service. And the reason why there are maybe less competitors is because Google does very, very well with their services. Yeah. I'm also very skeptical of all of this, and I posted on LinkedIn about that. I got also lots of negative comments, like I wouldn't care about data protection and this kind of stuff. It's just my choice that I want to use these services with as little clicks as possible. Yes?
Some things on the users that are not universally accepted. But I don't think, I think Google is not the right point in this chain of legislation to target this. I think it should be targeted to America so that it's not an EU exception, so that the Americans make their companies behave and not just duct tape in the EU.
Yeah.
It doesn't work.
Yes, and because that finally results in that everyone worldwide gets these services, but we don't. But the easiest way to make Google in your browser work again is just connect to London through a VPN. So maybe this is, the best business model for VPN service providers. I don't know. It turns out, or there's a very interesting word called a tech panic. And there's a very good paper that was written by Patrick Grady and Daniel Castro 2.5 years ago. And they wrote that there's a huge, tech panic around AI. People are scared about technology, but they went back in history and there were other tech panics before. Like, I don't know, more than 500 years ago when the printing machine was built, there was a tech panic too, that everyone would turn stupid from that, whatever. But I think overall education has increased a lot and we have benefited. I can really recommend Patrick Grady's document. I had given input to an earlier draft before the final version appeared. Very good work. I can highly recommend it to you. I know there are lots of further readings and probably you won't have time to read all of this, but for further reference, if you ever need to go back to this. Then parliaments, they can see AI from two sides. So I want to say a few words on this. So far, we've always seen parliaments regulate AI, but that's mainly in Europe. Most parliaments around the world, they're not really interested in this, or they have other concerns like increasing healthcare, scaling education, growing prosperity. I think fears around AI are the least concern for most parliaments in the world. But work in parliament itself is very manual. They type all these laws and then they don't fit together and so forth. And You may need some more background research. So there's also huge potential to actually apply AI to the processes within Parliament. And for this, I co-organized an event that was this year in May. There is an organization that probably most of you have never come across. It's called the IPU, the Inter-Parliamentary Union. That's something like the UN connects countries and governments. The IPU connects parliaments around the world. And almost all parliaments are a member of the IPU, the Inter-Parliamentary Union. And they felt they should do more work on AI. So the IPU is headquartered in Geneva. So in May, we had a school for members of parliament and parliamentary staff from various countries. And we met in May in Jordan for a week and discussed AI with the members of parliament and some of the staff, because they had lots of questions about AI. And, you know, maybe the members of parliament in some African nation, they have been far less exposed to AI than we have been exposed here in this degree program. So we discussed this, and I was one of the co-organizer, and one of my friends brought me in this event. The person is Rolf Hoyer. He was the Director General of CERN in the past, so the European Organization for Nuclear Research, and he was Director General at the time I was there, and he's retired now, but now he's doing this kind of work, working with parliaments, bringing people together. So I was very happy to help organizing this event. And yeah, we gave them some guidelines how they can use AI within parliaments for some of their work. And I think there's huge potential, because even in Germany, we have so many laws, but often they are contradictory. They refer from one law to another. The reference is wrong over time when laws get updated. And with this, maybe some NLP software can really help, and can maybe also help us to write shorter laws. Because I still believe the AI Act and also the stuff Christoph talked today about, all of this probably has a good intention, but maybe you can just compress it to 10 pages rather than hundreds of pages. By the way, the AI Act I mentioned, the first draft was 120, 140 pages, and it nearly tripled or something like this during 3 years in Brussels. And yeah, maybe a good intention, but with AI, maybe we can compress it to 10 pages, and then we can actually make it enforceable. Next point, so after regulation are patents. What do you think? Can we patent AI or not? If you think we can patent AI, maybe raise your hand. Okay, if we can, maybe raise your hand now if you think you cannot patent AI. So you raised your hand twice, but fine. Yeah. Yeah. First of all, that depends. Yes.
Data behind AI, but AI will always differ in how it uses these data. So
yeah. Okay.
Just because you use the same data for training doesn't necessarily mean you get out the same AI.
Yes.
I think you can edit the structure, for example, with encoder, decoder, for example, how you build up your LLM. But I don't think you can patent the data you use, because that's data maybe wasn't even allowed to use in the first place.
Okay. We'll collect. Next one.
As I would agree that you can patent the structure, the methods you use, but not the data, and especially not the results that you generate, for example, with generative AI, because that's just random. That's not really.
I think you're rather referring to copyright, maybe then. Okay. Copyrights are coming next there in the next subchapter. Yes.
I think patent really AI is what researchers do not have the capabilities then anymore to get better AI, because they are always with, yeah, this is patent and this is patent, we can't use that, we can't use that, we can't simply try out that structure. So I don't think this is really a good idea. So
Okay.
we will hinder research.
Yes.
I think it would make sense to be able to patent a model, a trained model, ready model to use, or like a particular implementation in software of the architecture, but you can't really patent mathematics behind all of it. It just
Mhm.
doesn't make sense.
And one more comment?
If it's for you get a patent on something, you need to prove that you developed there a certain like technical novelty, something very specific, is very specifically. Patenting AI or the use of large language models or something as a whole, I think is a bit too broad, and there are just too many contributors, and it's referencing like too many past research that you can sensibly put into one patent.
Yeah. Well, lots of comments. So I'm not a patent attorney, but I'll just provide a quick overview of, at least simplified, but I'll provide you with references after that. So a patent is meant to protect something novel, an invention that creates a novel effect. You can only patent stuff that is not publicly described yet, very importantly. So if you publish a research paper and it's out, you won't be able to patent that anymore because it's already in the public domain. And patents have, there's some criticism. Some people claim now in the 21st century, patents are outdated. One wouldn't need that anymore. It would stifle competition. But patents actually have a very good intention, because people share something they have done with the general public, but they get an exclusive right to use it for a certain amount of time. And so there are certain things you can patent, certain things you cannot patent. And I've said it needs to be, typically a patent would refer to some apparatus, so something that creates a certain effect, and this needs to be novel. And there are still more constraints. Now, what you can patent and how differs around the world. In Europe, we have the European Patent Convention and the European Patent Office, but there are other jurisdictions, like in the US, there's the United States Patent and Trademark Office, you have the Japan Patent Office, the China National Intellectual Administration, and so forth. So, and they have different regimes, what you can patent and what you cannot. In Europe, our understanding is that you cannot just patent maths and algorithms, but you can patent some machine, some apparatus, or some process in which AI contributes to some novel effect. So you cannot patent the AI as such, but something bigger, an apparatus or a process that includes partially AI to do something like this. For this, there were various rulings that clarified this. But if you look in the US, like 10, 15 years ago, Google got a lot of very strange patents on machine learning methods that were already publicly available. Google, I think, once even patented the concept of classifications, or in general. It's unclear, well, they got these patents, but it's unclear if they would actually, be enforceable in a trial. But it could already scare away others. But what I'm being told is that Google actually, they patent a lot, but they want to share the knowledge with others. So they rather block this before someone else gets a patent. But this is at least what they claim. I don't know. And in other parts of the world, maybe in India, whatever, there's a different patent regime. I'm not familiar with that. But in Europe, just patenting an algorithm or some equations, that does not work. Rather, it's a process or some apparatus that may include some AI. Yes?
Is very weak enforcement, very weak, until we get a competitive advantage in it, then they enforce it.
Okay.
Until you're weak in pharma industry, so patent laws are very loose, and you can just copy and mix up. When India got really good in pharma industry, then government enforced it, and then when we started making something, we just
Okay. Yeah. Interesting view about India. And I think there's also a lot of misunderstanding about patents. I think you remember this during COVID, there was this suggestion within Europe, because more doses of the vaccination were needed at a short amount of time. There was this proposal to temporarily suspend these patents around the vaccinations. Did you follow that discussion? When I talked to patent attorneys, they all said that this seemed to be total nonsense to them, because a patent is not a manual how to build something. It's rather a highlight or a high-level description of some process or some machine, but it's not a manual how to build something step by step. And then if you suspend these patents and allow others to produce these vaccinations as well, this would probably lead to a huge drop in quality, because you would have lots of people in the market that don't have that expertise. And it's very importantly not a manual how to build something step by step. And I think this is something that those in politics that had proposed that kind of stuff didn't really understand. We had a very, very good patent attorney here in this course 3 years ago, Anna Heide. She's a patent attorney specialized on AI in life sciences and healthcare. She was here 3 years ago for a guest lecture. This year we have other people, but she wrote a book chapter in one of my books a few years ago about patenting inventions involving AI in life sciences and healthcare. We have also this book chapter available in Nextcloud in case you want to learn more. Then you had mentioned the issue of copyrights before. So copyrights are, again, a totally different topic. And the copyrights is something that has been in the news for the last 3 or 4 years, that, for example, writers or newspapers sue OpenAI and others for copyright infringement over AI training. So copyrights and AI, you can see this from 2 directions. Copyright on the training data or the output, does that have a copyright? Now, in the US, the training part seems to be under-regulated. There is some uncertainty from my understanding what you're allowed to do and what you're not allowed to do. Here, we actually have one big advantage in the EU, because the training part is super relaxed. In the EU, we have a copyrights directive, and this one was revised maybe some 5 or 6 years ago. And that directive means it's implemented in some way in national laws. So what I'm referring to now is the German Act on Copyright and Related Rights, which is an implementation of the copyright directive. But it looks quite similar in most of the other member states. And there is section 44B, text and data mining. First of all, new wording. We've been speaking about AI the whole time and machine learning. So what is data mining? Complex question. What does data mining mean to you? Finding insights in data, which may include machine learning, but probably some other works as well, like visualizing data, pre-processing, something like this, right?
Mostly automated.
Okay. Again, probably everyone will disagree about what's the distinction between text or data mining and machine learning. To me, data mining simply means more than just the learning, because you have other steps as well and other methods maybe. But the good thing is there's a very simple legal definition in section 44B in the first part, and it says text and data mining means the automated analysis of individual or several digital or digitized works for the purpose of gathering information, in particular regarding patterns, trends, and correlations. So that's overall, I think, what we could also assume for machine learning. We want to find pattern, trends, correlations, and we can do this for data or specifically with regards to text, and then we speak about text mining. The next part says it is permitted to reproduce lawfully accessible works in order to carry out text and data mining. Copies are to be deleted when they are no longer needed to carry out text and data mining. So you can reproduce data for your text and data mining as long as you can lawfully access the data. What lawfully accessible means is the next question. But simplified, this means data that was not stolen, maybe data that doesn't fall under specific data protection laws and so forth. Yes.
For content behind the paywall.
That's one of the questions, probably that would not be lawfully accessible, but if you have access through an account, that's unclear. So you would need to ask a lawyer. I don't know.
Lawfully access the content, I give it into the training and then everybody else can access it.
For this, you would need to consult a lawyer, yes?
Because you bought a million copies and then burn it on other one,
Yeah.
isn't that the same principle? I mean, also not allowed officially.
Yeah, but here it is allowed as long as it's lawfully accessible. And if you have lawfully bought a CD, you were still not allowed to copy it.
Say it like this, because for example, if you train your LLM with that, everyone gets this information for free, while the author which would like the money for his information doesn't receive at one time it receives it, and millions of people have access to it.
For this, there's a part 3, which we will refer to very soon. Yes.
For example, if we go to the example to like generating fantasy stories, if you wouldn't allow AI to take to learn from things like Lord of the Rings or classical works that genre, we should also sue every modern fantasy writer because they most certainly took some sort of inspiration.
Yeah.
Previous fantasy books by Russian Tolkien or myths or something.
Yeah, what you said is something I find very good. Writers, they have been inspired by other writers. So we as humans, we read texts, we learn from them, we come up with our own texts. No one cares about that, but when it comes to a machine, it suddenly seems to be a problem. Now there is part 3, and it says uses in accordance with the subsection 2 I just referred to, sentence 1, are permitted only if they have not been reserved by the right holder. So the right holder could reserve this, and such a reservation of use in the case of works which are available online is effective only if it is made in a machine-readable format. So such a reservation of use must be in a machine-readable format. No one really knows, again, what this should look like. And this is something that courts will be looking in sooner or later. It was debated maybe a year ago whether subsection 2 actually, which refers to text and data mining, if this could be applied to machine learning. But I think the large majority says yes, all of this applies to machine learning as well, because there's a very broad definition. So this applies now to the training. Who has the copyright if you generate something with a Gen AI? Yeah.
Is there something decided yet? I think it's still
okay. Someone else raised a hand. Yeah, go ahead.
You are also, since you're also the editor who has to overlook it and check it for correctness.
Mm-hmm.
As far as I know, you have the copyright to what you generate because you also put the energy of the building the prompt.
Okay. This is the part that is actually unregulated at the moment in the EU. But our understanding in Europe is that that only humans can be the copyright holder, not a machine. So who has the copyright? Unclear. A lot of lawyers keep telling me, you as the human, you would anyway take the output, you would amend it in some way or another, improve it, and you just don't need to, maybe you would just not write next to it that it came originally out of a Gen AI and you claim it's yours. This is not my advice, but some lawyers are saying that this would probably be the most practical approach. Yes?
Can companies have copyright or do they have?
No. They have trade secrets, but copyright, at least in Europe, only applies to humans.
And CEO of a company say this is my copyright on the founder.
Well, here, but the company is allowed to use it because that's what you sign in your contract, that all your works can be used. But you were still the one that sort of came up with that, and that right you cannot seize. In other parts of the world, what I hear, especially Japan, they are very relaxed about copyrights and AI. I think also in India, when I saw this in the news, very relaxed regime with regards to copyrights and training AI. And we're coming now to the last two sections. Military AI is the next one. Something we had seen yesterday already in Alexander's guest lecture. So what is military AI about? I started publishing about this already 4 years ago, before the conflict between Russia and the Ukraine, because I saw that conflict between Armenia and Azerbaijan, in which, for example, drones played a major role. And for the last 6 years, I've been collaborating with professors at the military university next to Munich. The German military has 2 universities, one next to Munich and one in Hamburg. And I felt overall there was lots of potential for AI in the German military, and autonomous weapon systems are just the end we will come to later, but other things like logistics, personal planning, training planning, situation analysis. So non-invasive things for which AI can play a big role, like to analyze satellite images, battlefields, and so forth. So I wrote an article about AI for the future development of the German military. And there's the most famous German magazine for military. It's called Wehrtechnik, so military technology. And I wrote an article there, which actually led to lots of reactions. In that time, I didn't care too much about autonomous weapon systems because this was something that less people talked about. I rather saw other opportunities like logistics, situation analysis, battlefield analysis, and the other things I mentioned. But then obviously, the conflict between Russia and Ukraine has started, and this has sparked huge interest in advancing AI for military. And there was a very interesting conference on this topic last year called REAIM, which is the Responsible AI in the Military Domain Summit, which took place last year in September in South Korea. And I was there. I submitted, together with one of my associates, we submitted a session that we ran at this conference. And what we felt at the REAIM conference was 90% of the speakers came from this Red Cross, NGO, extreme left-wing domain. And they said, oh, autonomous weapons are evil, we have to ban them. And obviously the best thing would be we don't have any wars, but our potential adversaries, they will use them anyway, even if we ban them. And the adversaries may also be non-state actors like terrorists. And in order to be able to defend ourselves, we have to invest in this stuff too, to be at eye level. Otherwise, it probably means lives lost. That's something that many people did not talk about at this conference, but my associate and I, concretely Dr. Andreas Leupold, he's a lawyer and a tech lawyer working also on military deals and so forth. We submitted our session and we said, mission possible, building safe and reliable autonomous weapon systems, which was probably not what the conference organizers intended, but we got it accepted. And there were very interesting people we had a discussion with. So we had a few panelists, and there was, for example, one representative from the Pentagon policy group. So they also look into this. And we said something like, yeah, the best thing would be no wars, obviously, but if we have machines battling each other, that's probably better than if we have humans' lives lost. And we also see in wars, there are always human or civilian casualties, people not involved, and they get killed by humans. Now, we've looked into various laws, how you could build safe and reliable autonomous weapon systems. Because, first of all, war is regulated already by the Geneva Conventions. And they allow to kill people if certain conditions are met. So not just kill randomly people, but there are some conditions in a war, and then you're allowed to carry out military force against troops, not against civilians. So if we can protect or spare civilians because we do better intelligence and better precision strikes through an AI, I think it's very helpful. And wait a second, and how do we build safe systems, and how do we reduce liability? Because there are even articles in big newspapers, they claim AI in military was totally unregulated, super unsafe, and just a big risk. So we looked into it. So we checked the Geneva Conventions, and they don't focus on a specific technology or humans at all. So AI would be compliant with the Geneva Conventions. And then we saw, if we follow the Geneva Conventions, so humans still need to decide about the overall mission objective. For the individual target selection, the AI could come into place, because the AI has to make certain decisions in real time. There's often this discussion, you need a human in the loop, but if you have a human in the loop for every detail, that means you don't have an autonomous system. And probably you're just too late then. Say, if you have an autonomous fighter jet, that one has to react very quickly rather than waiting for a human for 10 seconds to make some ultimate decision. And then we wondered how can we build safe AI systems? For this, we've talked about methodology before, like quantifying uncertainty, transparent AI, reducing bias. I've talked about this earlier today. And then it comes to product liability. So we suggest that product liability laws should be also applied to autonomous weapon systems. Because no one, I've seen you, just wait a second, because no one had really proposed that before. So Andreas and I proposed that. And product liability, very importantly, does not mean that your system must be free of error. Because if that was a requirement, then we wouldn't have any products on the market, even no toys. But product liability means, or the laws require that when you develop and deploy and run these systems, you follow the state of the art of science and technology. And if you do that, and you deploy your products, be it even toys or cars, and something goes wrong, then, and you can show that you have followed all of these requirements, like the state of the art in science and technology, then you're not liable if something goes wrong. And we suggest to apply this principle to autonomous weapon systems as well. And obviously some rules how to build safe and reliable AI systems with regards to military would need to specify it more, because there is a lack of that. But for this, you can do standardization. So please.
We're talking about, or we are living in a peaceful era here in Germany. I don't really think that this matters anymore if you are at war. So when we look at Ukraine or look at Russia, for example, they are mass producing these drones. I don't really think we are any longer caring about if they are reliable or if they are just efficient. Also not if they are precise, just efficient to kill.
That's the sad reality, but the German government is committed to the Geneva Conventions, and we cannot seriously propose a concept in which we violate this. But does the US always follow the Geneva Convention? Probably not. Yeah, but at least to date, I mean, there are also some people telling me, even from military, if it or from the military university that they believe if the big war happened, no one would care about all of this anymore. But at least at present time, I think a discussion like this at such a conference would just lead to total chaos. But we think there's a way how to build safe and reliable weapon systems of that sort by connecting the Geneva Conventions with standardization of AI and product liability laws. I think there was a question in, yes?
What the battlefield of the future will look like. So both sides have autonomous drones, maybe autonomous fighter jets. Will there be any soldiers involved? And will such a war go? Is it just you bomb each other with material that the one who is first out of drones just loses because he gets overrun? Or at which point does the human soldier come in?
Maybe later, at a later stage, when maybe there are no drones left, you know.
Yes.
It's
just a battle.
But if first of all machines fight each other and we spare human life, maybe that's not such a bad idea.
No,
I think you had raised your hand next.
So I segregate AIs into like two basic categories, I assume so. So the AIs which exist in battlefield, which assist the soldiers, and also the AIs which are far from the battlefield, which analyze the patterns of the wars and also help them or the war generals which take them actions. But the question is, can AI can really show humanity as a soldier shows? For example, I have seen a video of circulating a Ukraine soldier maybe was injured, badly injured. A Russian drone has dropped some water bottle so that he can be assisted. But the drone itself was controlled by a human. Because that's why I see that human can show and humanity even to an enemy. But can an AI, which is completely auto-driven or data-driven, could show some humanity or empathy even in war? This is a big question.
I think that's an open question. We'll see how this evolves. I think you raised your hand next.
These methods that just give, first of all, as was said a few times now, saving soldiers at the front lines, but with these probably more precise and therefore only consider warfare, you will also reduce the horrors of war on the civilian. Because you wouldn't have these like grueling several days, several month sieges. Just target the priority targets with highly precise drone strikes.
Yes, that's what I also feel. And I said before, we should spare civilians because they are protected by the Geneva Conventions. And for this, more precise and better intelligence can certainly help that we have less losses among civilians. Yes? No, the other guy.
Think one outside could be that the threshold to start a war could go down. So some people could think, yeah, we are only letting our machines fight, but in the end, like some people said, if the machines are out of resources, you send your soldiers into the land and let the soldiers fight the machines, and then you have people getting killed again. And I think could be a problem.
Yeah, the threshold for conflicts could decrease because we first sent in robots. I agree with that. Yes.
I think I'm so in most cases before a war starts, you have on both sides, or especially on the aggressor side, a lot of propaganda and stuff that dehumanize the other side. So they usually bring the threshold already down to a level where it is acceptable. I think it will not go up if the threat of the high facilities to the parts, like a president or highway in generals, is more imminent than just throwing throwing soldiers at the front line. I think it would rather increase the threat because the people that make the decision are threatened and only soldiers.
Mm.
with high positioning, high tech systems.
I think you've in the front here had raised your hand before, or one of you, I don't know.
Is there a trailer for author or something? It's about Corbinian's question how modern war would look like. And I think in this trailer it was about an AI system that controlled a plane, and all the passengers were already dead on the plane long ago because the AI is just giving out orders and bombing the other AI. So life is no longer existent on Earth, and or you're the last survivor or something like that. And there is just AI that is flying attacks against each other with really no longer any reason for that.
I see. I think there was something like this, yeah, in the movie, but I don't remember this. You raised your.
One frivolous comment, you can just run an AI simulation of war between two countries and see which one wins, and just avoid the war completely. So obviously that's not going to happen. But there is two ways to deter any war. It is to solve underlying political problem whatever there is, because war is not helping people to achieve political objectives. And second one is to build deterrence. So I think the focus should be on obviously solving whatever issues that we have, but the focus should be on deterrence. So your capability should be so high that other country does not think of an attacking war.
Mhm. Yeah, a good point. I think there was one more hand raised.
I actually think that it would help the government to maybe, like, for example, the USA, because it is the example for making a war out of nothing, or let's say like going to somewhere and make their war. And in the end, for example, in Vietnam, the people in the USA were against it. And
Yeah.
that was the pressure which led them to go away from there. And if we are taking only machines there, it's like in a fabric where only robot arms are working. Nobody would say, oh, they have a 24-hour shift. That's not
Yeah.
fair. But if humans could work there 24 hours, everyone would like, that's not okay. And I think that would be the same there, because there is no reason to say, oh, okay, we are sending machines. Maybe it's not good. Many people wouldn't care about it.
Yeah. Yeah, probably many people wouldn't care if just machines kill each other. Well, if humans' life get lost, more people care. We got a very good comment here or question in the chat. So one student said he saw that Palantir has an LLM that helps, that enables soldiers to interact and decide about certain military actions through an LLM. What do I think about, or what do we think about this? While keeping in mind current issues in LLMs, such as hallucinations. So such systems, obviously, they can be in a supportive role, but finally, the soldier or the command center would still need to make the final call. And here maybe explainable AI would have an even more important role, that the LLM would also explain why it proposes something. And then, but finally, we should leave that decision to the human. But I think this military AI stuff, we could keep discussing for 2 more hours. So I want to thank you for all your comments, but we can, and feel free to, maybe some of you want to pick military AI for your for your case study or something. We will see. So Andreas and I, we wrote an article in Frankfurter Allgemeine Zeitung last year after we returned from South Korea. And then we explained our position in greater detail with an article in Wehrtechnik, which was in German. And then shortly after, we also wrote an article in English in another magazine from the same publisher called, the magazine is called Naval Forces, and there we wrote the English version of our article. So all of this is in Nextcloud in case you want to study it. And the last piece of today is AI at the workplace. This is something that got traction in recent months, recent years, because we see that AI is changing jobs, and some jobs are disappearing. And when I work closely with companies, usually with the executives, and we discuss where we could introduce AI, this may obviously create concerns about job safety with the employees. And that's why change management is super important, because maybe there are some tasks that these people don't like. And if we can automate them first, maybe we can get their support. You should also never underestimate how much workers' councils can slow you down in Germany. So you should include them early in such discussions. Sometimes I'm at some executive seminars with the leadership of a company, and I ask, is there also someone from the workers' council or the union? They say, no, we will inform them at the very end about AI. But I say we should inform them early, because if they find out we are doing something and they don't know about this, they might become even more suspicious. And we can include them in the decision making. And maybe there are some tasks they just don't like, and we can automate them first, and we can get their support early, or we send them to further training. There are also specific training courses on AI for members of workers' councils, because often these are workers, often these are not the engineers of a company, so they may also not understand statistics and this kind of stuff, but there are courses and you can train them and then hopefully get their support. But change management is very important, and sometimes unexpected stuff happens. Earlier this year, I talked to a lady who works at an insurance company, and she told me they have introduced AI there to handle some of the cases. And we always tend to say, let's automate the easy cases first. And that's what they have done. But she said now she only has the difficult cases left on her desk. And before, she liked looking at the simple cases for relaxation. And now, if you let these people work 40 hours per week only on the tough stuff, they tend to burn out very quickly, because they also need some of those simpler tasks in between for relaxation or just to reduce stress. I don't have the ultimate answer how to address this, but maybe sometimes you would give still some of the easy tasks to them and let it run by the AI in parallel. And this is how you can also maybe get more checks or see if you could train the AI even better. Yes? That would be the next step then. But in the first step, the AI simply processed the simple cases. And what you suggested could be the next step, that maybe the AI does part of the tough case. But currently, they are rather in a very bad position in terms of change management. And obviously, employees, if you don't include them early, this could lead to a strike against AI, something we have seen in Hollywood. Introducing transparent AI or explainable AI can be very helpful to get support from employees. And you simply need to train them that they understand that what an AI is, that it makes mistakes, all stuff that is obvious to you, but a lot of people in the general public, they believe an AI would not make any mistakes. An AI would be free of error, but AIs make mistakes. And if you communicate this may help. There was also a hearing about this in the European Parliament a few months ago, because now the EU, after the AI Act, there are some voices in the European Parliament, and they are wondering if AI at the workplace was not regulated well yet. So they feel this could be covered with another law. I was there as an expert witness. I spoke out against this because there's already lots of protection for employees, be it through GDPR and other anti-discrimination laws. So it's unclear if one would actually need more regulation, but they invited some other expert witnesses. I was the only one doing AI. They invited an economist, a lawyer, someone from the union, someone from corporate representation. And in that hearing, it was about AI, but a lot of stuff got mixed up, because some of the other expert witnesses, they saw AI and algorithms as synonyms, and they mixed up algorithms, AI, and platform work. So platform work is something like working as a freelancer with Uber or Delivery Hero or whatever. And all of that got mixed up in the hearing, and finally no one was really any smarter than before. That's something that confused me a bit. So Last part of today, I will say again a few sentences about the case study, because we have now started, well, we have finished today AI in law as well as contemporary challenges. Yesterday, we looked at the AI transformation of a company, recent challenges or progress in the deep learning world, as well as history and promises of AI. Now we'll come to the case study. You need to be groups of 2 to 3 students. You need to think about a case study on your own. Yesterday, I informed you about that. Well, now my browser is, since my computer, well, it's actually back, surprisingly. Because the deadline for this, what you need to submit is November 19. The submission is already open in iLearn. All you need to submit is your topic, so just the title and no big abstract, your names and student IDs of all the group members, as well as your degree program. And then your presentation will be either on the weekend 13th and 14th of December or the 20th and 21st. Register in Primus, and your presentation will take 15 minutes, and you're very free in which case study you pick. I've mentioned this yesterday. You can pick any company you wish, either the company you're working at the moment or some other company, some problem you find on the internet, some problem you would see at the place you are working at or that you worked at. But it's very important that your case study not only covers technical challenges, because how to train a neural network in detail, for this we have other courses. You can cover some technical challenges, but also some of the stuff we have discussed in this course, be it legal, be it from organization, whether AI is actually the solution or not, can address some of the contemporary challenges like fears around AI, explainable AI, business models, how to earn money from this. So you're overall very free in this, and there's lots of references on the internet and in the further readings I provided. So your presentation would be 15 minutes plus 5-minute Q&A. All of the presentations take place on campus, unless your internship is really that far away, typically outside Europe, that you can't be here. And if that's the case, you need to contact me individually. And remember the other rules that I mentioned here, that you cannot choose the time. You need to attend all the presentations on the day of your presentation. Otherwise, you fail. But I discussed this yesterday in detail. And today, I've seen you can still look for some group members. So we have around 25 students in here. We had 20 online. Overall, I thought more students are taking the course, because we have exchange students, we have more students from the English language program. So I guess some of them are just watching the recordings, or they're trying to take the course without being here and without watching the recordings, which is probably not a very smart choice. But this is all my key information on the case study, and it's a pass or fail since it's one of these internship accompanying courses. Yeah, any questions? Yes?
The German course has a special weekend for only the German course. This is all right
if you are from the German program and you want to present in German, that's fine. Because it should be that many students that we cannot really do it on one weekend, and that's why we put it on we put everyone on 2 weekends. We will finally see if maybe one Saturday on one weekend is enough. I just need to see how many submissions are coming in. But if you mix with other students from the English language program, then your presentation would anyway be in English. Yes?
There's a scheme, in your other courses, you have a scheme for points distribution. I know there are no points, but just for
No, not really, because the case studies are that different. So there isn't much of a marking scheme, but getting the fail, you would really need to screw it up. I don't think anyone failed this before. Unless they didn't show up or something like this, or unless it was super bad. But you should still be familiar with the content, and there will be a Q&A session, and I will be more tough now in the Q&A session also with regards to the course, because every year students, they take seminars or do projects without attending the course in the first place. Let's see if there are any questions in the chat. Yes?
Is this course gonna only be taken if you are doing an internship, or else we can take this course individually and do the internship later?
So this course runs in the 5th semester, in which most students would do their internship. So you can benefit the most if you do your internship in parallel. However, if you have done your internship already or you will do it in the future, you can obviously take the course now. But if you are in some real world setting in parallel, obviously the learning experience would be even better. But if you have free time, if you have free capacities this term, then don't move it, because we only offer the course in the winter terms. So some students, they may choose to do their internship in the next summer term, and then we only offer this course in the winter. All right, with there not being any further questions, I want to thank you for all the discussions, and I look forward to your case studies in December. Enjoy the remainder of your internship or term, and see you in 2 months. Take care.